Budavenge, the legal way, welcoming you back to my channel. We are talking about financial support for children called maintenance, and this is to be paid by the non-custodial parent for the upkeep of the child. And normally our courts will grant these orders to be paid monthly, but in certain instances, a lump sum payment can actually be ordered in terms of the Maintenance Act. Now, some of the circumstances that are considered are maybe the fact that the non-custodial parent might be moving out of the jurisdiction. The non-custodial parent might have difficulty paying on a monthly basis. Or a very good example is that maybe they've received a pension, maybe they've received a particularly large payout, and they want to pay a globular sum of maintenance, and it is allowed at law. So maybe they want to pay $10,000. They want to pay way more than that. And in a recent case that has been quite popular on social media, case of Wikno Chivayo and Sonia, as they're concluding their divorce or in the process of doing so. Record lump sum maintenance, they're paid 5 million United States dollars, and with conditions that it be put in a trust and managed for the upkeep of the children. So this is not absurd or something out of the ordinary. Our Maintenance Act actually does allow, in various circumstances, upon application of the non-custodial parent, for lump sum maintenance to be paid. What are the advantages of this? Well, the very quick answer to that is that the money is all there, and so for any needs that may arise, it can then just be taken out and used for the benefit of the children. Some of the risks might be that it could be devalued maybe by inflation. And then there's always the aspect of mismanagement as a risk there. And also the fact that it's difficult, if not impossible, for you to then get a variation upwards. At what point are you going to seek that if maintenance has been paid for 5-10 years or even longer until the children attain the age of 18? So then moving on to another important aspect, I'm often asked by so many people, can I vary the amount of maintenance? Or sometimes the non-custodial parent will ask, can I get it reduced? My circumstances have changed. I lost my job. I'm sick now. I had an injury at work. And the answer to that is yes. Our law does allow for variation of maintenance, either upwards or downwards. What you have to do as the non-custodial parent, the one whom the order to pay maintenance was entered against, is show that there has been a change in circumstances. On the other foot, the custodial parent can also show that maybe the children's needs have increased. A child is now, elevated from preschool going to high school, from day school going to boarding school, or maybe they've been injured, maybe they've developed a condition that now requires that additional support. So you have to approach the court and put forward your circumstances, and the court will then determine whether indeed there have been changed circumstances. And if they find that there are changed circumstances, they can either vary the maintenance upwards or downwards.